Visha. Okay, ladies and gentlemen, welcome to this session. This session is about mediation, and we were doing something called Coffee with a Bar, and Bala was doing something called LEX TALk. So Bala and me had a chat one day, and we decided that we would do this together. And believe me, we had a lot of fun and laughter preparing for this session. And the reason and the contents of what we laughed about or what we gossiped about, obviously, we cannot be mentioning in public forum. Anyway, we thought that apart from whatever be the laws per se, which are being the subject matter of various webinars all around almost the country, we thought we would have something that is not strictly the law, and that is where mediation comes in. And mediation being such a big thing, especially with a lot of people now saying that in view of the COVID-19 implications and consequences, fresh negotiations are the order of the day. So mediation is here to play a big part even in this particular scenario, and to interact and to discuss and to share their insights and views about this particular issue. We have four panelists, two from Madras and two from England. The first panelist from Madras is Justice N. Govindaraj. After almost 28 years of practice in various fields before he was elevated, he, during this time, he also became a mediator. Subsequently, he became a trainer and trained many mediators across the country. He was elevated to the bench in October 2016, and after becoming a judge as well, mediation has been given its due importance by Justice Govindaraj, and therefore he brings to this session three views: one as a mediator, one as a trainer, and the third one as a judge, and that is Justice Govindaraj. And let me be the first person to officially live wish him on public forum happy birthday. We'll take our sweets later. Thank you for being with us, Justice Govindaraj. The second panelist is Bharata Chakravarthy, advocate, a practicing lawyer since 1993. He's right now the public prosecutor for the Union Territory of Pondicherry at the Madras High Court. He's an accredited mediator and a trainer from the year 2005. Mediated over 400 cases, and several lawyers and judges have been trained by him across the country. Now that's this side of the Atlantic. From the other side of the Atlantic, we have this firm in the UK called Andrew Jackson Solicitors LLP, which is a commercial law firm based in Hull, with a presence or branches in York, Grimsby, and that place that's been made famous by that song, Scarborough. Domnic Ward, who's the senior partner and the head of shipping and the trade department in Andrew Jackson, has specialized in international sale of goods, including shipping and transportation, for 33 years and more. Domnic has been a part of many mediations in which his clients have been effectively and actively involved, and therefore his presence here lends an international flavor to the entire session. Richard Hoare, partner and head of the private client department. This particular private client department, which includes the family law section of Andrew Jackson, has been operating a dedicated family mediation service for the last 20 years and so. Richard personally has been a family law specialist for more than 25 years. He's a qualified family arbitrator and a collaborative lawyer. The area of expertise is with reference to financial disputes arising from relationship breakdown. And if WhatsApp and the news around on social media is to be believed, Richard is probably the man who will be a very, very wanted person after this lockdown ends in respect of domestic relationships. Thank you, Richard. And Richard, Domnic and Richard, welcome to India, and though not physically, virtually welcome to India. Thank you very much. And now we throw the floor open to Justice Govindaraj. You have to switch on, unmute your mic. And start.
Good evening, friends. I'm very happy to share my experiences with you. Let's talk over coffee. I think Mr. Sriram asked me that it will not be like a webinar which gives lectures and other things, but where we are going to share only the our experiences, and that we are going to have an interactive session. Now, today the topic is my favorite subject is mediation. Straight away, without exchanging the pleasantries, I go into this subject. That mediation, you all know that after Salem Bar Association case, Section 89 of Civil Procedure Code was got amended, giving this alternative dispute resolution by settling the dispute outside the court by means of arbitration, conciliation, judicial settlement, and mediation. So, out of all these ADR methods, I feel the mediation has salient features, is significant because in all other methods, that a third person decides your case. He gives a judgment. Whereas in mediation, it is decided by the parties themselves. That is the salient feature of mediation. And mediation is a voluntary and confidential process which is facilitated by a third party, neutral third party, who's called a mediator. And I know that most of you are at least some senior lawyers who are all trained mediators, and you know well. For the benefit of junior lawyers, I want to explain this mediation process. It is a voluntary process. In India, it is a voluntary process where the option is given to the parties to take mediation or not from the threshold. From the beginning of the mediation till the end, if he is not willing, he can walk out. And this process will be kept confidential, that will not affect their cases in the court, because mostly we are doing court annex mediation. And this scope of the private mediation has not developed much in India, but for the present we are doing only court annex mediation. Here in India, that I will proudly say that mediation is started in Madras High Court the first. We are the pioneers in mediation in India. After amendment in the year 2004, the first batch of mediators were trained. The then Chief Justice, Honorable Mr. Justice Markandeya Kaju, initiated this movement, and Mr. Sriram Panchu and others, they have spearheaded it, and we all trained. And after that, it was extended to district level in the year 2005. The then President, Mr. Abdul Kalam, has inaugurated that mediation program. So, to be short, that we can say that mediation is a voluntary process where disputants, through a mediator, settle their dispute. Here, I would say that mediation is the best method because there cannot be any appeal against it. Both the parties end in a win-win situation. Both will have the satisfaction that they have got what they wanted. What is need and want is the basic thing. You are taking a position, and wanting something is different from what you need. In mediation, the mediator makes you to understand, or yourself, disputed himself understands what is his cases, and how much will he get, and how much will satisfy him. So it addresses the emotional aspect, procedural aspect, and substantive requirement need of a person. Once a person gets what he needs, he happily settles for that. So in that way, both the parties, they end up in win-win situation. Then there will not be any wound or feeling that they were defeated, and so that they will to wreak vengeance, they go on filing appeals after appeals. Here is a case where the finality is achieved by a mutually agreeable settlement. So both the parties will be very happy. In Madras, in 2004, I said that we have started this. At the beginning, it was a pro bono service. We have done it for free. There, we had satisfaction that we could commit ourselves and do some service in return to the society. In mediation, we get soul satisfaction. And there are a lot of mediators now volunteering themselves to do this human service. Now it is very remunerative also. And in future, we hope that will expand in a large scale. The best method, unlike arbitration or judicial settlement, lok adalat, mediation would be preferred the most because it brings harmony and peace in the remuneration, because what we now get in India is just 1% or below 1% of the litigations coming to court, remaining 99% settled outside. But now, as of today, that is a voluntary process in India, and several countries it is a mandatory process. One should undergo the mediation, and then only they can file the case. If they do not sincerely attempt that mediation process, and I think cost will be imposed upon them. We have our friends Richard and Domnic to explain on this on the UK system also. I also wish this mediation should be made mandatory. Supreme Court in this recent case, in Krishnamurthy's case, they have said in Motor Accident Mediation Act, that MAMA Act, wherein the scope is enlarged, where it is made, it will be made compulsory that the parties should undergo mediation at some point, either before taking into cognizance, taking the case for trial before the judge, or after the judge refers to mediation. Mr. Bharat will explain it later. Just I'm giving the outline how the mediation is going on in India, and you'll all be benefited. There are certain conditions there, because there is to avoid overcrowding. We are selecting people who have minimum 10 years of service and who has reached 40 years of age, and there is a selection process. But learning will not stop you. You will acquire more knowledge by learning it, and we have mediation awareness programs in Madras High Court and throughout Tamilnadu, so that the young lawyers who can learn mediation. So when you go as a counsel for the disputant before the mediator or on the mediation table, you should know what is happening there, what is the mediation process. Today, I'm very happy that Mr. Sriram asked me to open up this LEX TALK. So when you come across whatever doubts you have, we'll answering that. Now I'll switch over to the other speaker, and I'll come back to you whenever you ask a specific question to me.
Domnic, would you like to take over from here?
I will do. Thank you very much. Hopefully you can all hear me. First of all, my thanks to Sriram and Bala for inviting me to speak at this coffee afternoon, evening in your case. So I'm going to talk about our experience of mediation in the commercial dispute scenario in England, and my colleague Richard will follow me to explain, in particular, the perception from the private client family law sector, where the uptake has been much better, and the structure of it is very different. My field of work is international trade and shipping, and the mediations I've been involved in have all, I think, involved in international litigants. Sometimes none of them based in England, and sometimes only one or two parties based in England. Unlike the Indian experience, the mediation practice in the commercial sector, commercial litigation area, is all private. There is no court mediation system that's been up and running, and so it is entirely up to the parties and their advisors to agree to mediate. It has a very high success rate. Anywhere between 75 and 85% of cases that go to mediation end up settling. Despite that, the uptake has been disappointing. It has grown for many years. It has grown, but it is still, relative to the number of cases that are brought, it's still a slightly disappointing uptake given how successful it is. We first started to really press the mediation button here in England in 1999, when our court procedure rules were completely rewritten. The author of the rules was Lord Woolf, who was a passionate advocate of mediation and also a pragmatist. The courts were becoming logjammed with cases, and they were taking a long time to reach their conclusion. And so it was obvious that if more cases settled, there would be fewer trials and the court system would be freed up. And that was the main motivation behind bringing in the requirement to consider whether a case can be mediated. And a succession of very senior judges who have all been advocates of mediation have gone on record in formal way to say that almost every case is suitable for mediation. The CPR, the civil procedure rules, have been changed, and the business and property courts' particular rules have been changed over the years, so that solicitors conducting litigation are required to complete a form in which they certify that they have advised their clients about mediation. And if the client has indicated they don't want to go to mediation, the lawyer has to explain why that is. And even then, at the case management conference, which is a procedural hearing, the judge can more or less insist that they try. He cannot make them, compel them. It is a voluntary thing, but he can certainly put pressure on the parties to mediate. The other weapon at the court's disposal is costs. As you know, in England, we have a cost scenario where the loser pays the winner's costs. But there have been a number of cases where the winner of a case after trial has not been awarded its costs because it was felt that they unreasonably refused to mediate during the life of the case, and that a successful outcome could have been achieved earlier and at less expense had they agreed to mediate. So the costs regime has been used almost as a penalty for parties that have been unreasonable in refusing to mediate. Notwithstanding all of those efforts, it's still been, I think, a slightly disappointing uptake, although it is common. And in fact, one of my colleagues was telling me the other day he had a 12-hour mediation on Zoom with the mediator conducting the mediation by allocating the parties to separate rooms within the Zoom call, and it culminated in a successful settlement. So one of the great advantages of mediation is its flexibility, because the solution to a case can often be more than just cash. It can be an ongoing commercial relationship is preserved, and indeed it may be that part of a settlement involves a commercial dynamic involved in the parties' discounted purchasing terms for a period of time, something that's not possible in a court order. I'm personally a big fan of mediation. I've conducted many of them. I advise my clients to try them whenever the opportunity arises, and they have all, 80% is about the success rate that I've enjoyed as well. Much depends on the mediator, and much depends on the party's attitude. One of the things I think is crucial is to reinforce the message that the process is confidential. There is a couple of big barriers to mediation. One is cost, which I'll come back to. The other is fear. Fear of disclosing your position, fear of disclosing your hand before you get to trial. But it's a fear that needs to be overcome by a party if they're thinking sensibly about the economics. In terms of cost, I think lawyers in England have a little bit to answer for. Most commercial mediations are private, so you have to pay for the mediator's time. Most mediators charge between £5,000 to £10,000 a day. There's often room hire, although Zoom may change all of that, so you need to hire a venue. And then what has happened in England is that the mediation process has become very formal and, if I may say so, slightly over-lawyered. So you have position papers being filed, sometimes 3 or 4 lever arch files of documents. It almost turns into a mini full trial. And of course, the cost of all of that with an unknown outcome, because it may be the parties won't settle, can be off-putting and is a barrier. I'm going to hand on to Richard because I think the experience in the family sector is much more user-friendly, and therefore, perhaps not surprisingly, the uptake has been a bit better. So if I may, I'll hand over to Richard.
Thanks very much indeed, Dominic, and thank you also, Sriram, for inviting us to speak to you this evening, and very good evening to you all. As Dominic was just saying, the experience in the family law context is a rather different one as far as mediation is concerned. The mediation process is rather less formal than in the commercial environment that Dominic's just talked about. Typically, family mediation cases focus on one or both of the following issues: either child arrangements, so issues concerning arrangements relating to children arising from relationship breakdown, so that may be contact issues or specific points of issue in relation to children, such as names or medical treatment, or it may involve disputes relating to financial aspects arising from separation. And quite often, mediation will cover both of those areas, so both children and finances, what we term as all issues mediation for the purposes of family mediation in England. One key difference between the way that family mediation operates in this country as opposed to commercial mediation is that the parties attend the mediation alone. They're not there present with their lawyers. So the concept that Dominic's just talked about of position statements and bundles being prepared for mediation sessions just doesn't exist in the family law environment, because the parties are there in person, but not with lawyers present. And they're then with the mediator, who is their role is to facilitate constructive discussion between the parties aimed at reaching a resolution. Now, again, unlike the commercial scenario, where usually mediations are concluded in a single day, often a very long day, as Dominic was just describing, family mediations are more routinely concluded over the course of 2, 3, or even 4 mediation sessions that are spread perhaps 2 or 4 weeks apart. So the actual mediation process itself will often take 3 to 4 months to conclude. And whilst in itself that's a reasonably lengthy period of time, by contrast with the litigation process and the court process, the length of time that litigation takes to conclude, it compares very favourably indeed. Mediation in family law has been operating for around about 30 years, but really the main focus on mediation in the family justice system in England and Wales has been during the course of the past 20 years. And the Wolf reforms that Dominic was referring to were also a prompt for family mediation to take a more prominent role within the family justice system. The way that the family mediation process operates is, again, as Domnic was indicating, it's not a court-arranged process. It's not a court-led process. It's very much a private process for couples who are going through relationship breakdown to initiate. But there have been a couple of steps taken over the course of the last 20 years by the government in this country to try to prompt and give some encouragement to the family mediation process. Now those steps have worked to a greater or lesser extent, and I'll contrast the way that they've operated for you. The first step that was taken by the government was to require that before public funding, so legal aid, which was freely available until a few years ago in this country for family cases, but before public funding, before legal aid could be obtained by a party to bring family proceedings, a referral to mediation had to be made. So a party had to consider whether mediation was appropriate, and that would entail them attending what's known as a mediation information and assessment meeting, what we call a MIAM, so that they could get information about the mediation process and they could consider whether that might be a palatable alternative to litigating. And hopefully that meeting would also allow the mediator to explain the benefits of the mediation process to the party concerned, and hopefully to encourage the mediation process to actually proceed. Now that proved to be extremely successful, not just in legal aid cases, but it helped to promote the whole notion of mediation within the family justice system. Before that, there'd been, it's fair to say, a fair degree of scepticism, not least amongst lawyers, partly about the success rate within mediation and about the process itself, and partly also, I'm afraid to say, because lawyers were reluctant to refer their clients to another process where they wouldn't necessarily have involvement, very much involvement in that process, because, as I say, the clients would be attending mediation themselves in person without their lawyer present. But because of the relative success of the requirement for individuals to at least find out information about mediation before they could obtain legal aid, that helped to improve the public perception of mediation. And also, it also demonstrated to lawyers that actually the mediation process did have real value and would help to unlock disputes between couples and create, as his lordship was indicating earlier on, much more longer lasting settlements between couples. Now, unfortunately, in 2012, the government in this country radically reformed the availability of legal aid as a cost saving measure. And as a result of that, legal aid for family cases was all but removed, save for cases concerning domestic violence or particularly urgent scenarios. And so that availability of, or that requirement for mediation to be considered before legal aid could be applied for didn't really operate any longer. Instead, what the government has done is now to require that before a court application can be made within family proceedings, that again, the applicant must attend a mediation information and assessment meeting to consider whether mediation would be appropriate. Now, the difficulty with that as a procedural requirement is that by the time somebody is contemplating an application to the court, often many weeks, if not months, will have passed since the relationship breakdown has occurred. And quite often there will have already been significant exchanges between the couple and possibly their lawyers, if they've engaged lawyers, about the points that are in dispute between them. And so the positions have become much more entrenched by the time that they're actually contemplating an application to the court. And so as mediators, we find that it's much more difficult to persuade clients that they should mediate against the background of an increasingly hostile dispute between them, and B, to actually help them to, if they do go ahead with mediation, to actually reach an agreement between themselves. So it's fair to say that since the legal aid reforms introduced in 2012, that mediation has been a more difficult sell to couples going through relationship breakdown. Having said that, because mediation as a process has become much more commonplace in the family justice system, it is a regular feature of the dispute resolution options that are available, and the courts have become more willing to encourage couples to go through the mediation process than was previously the case. So now, as part of the child arrangement program that operates within children proceedings under the family justice system in England, judges are required at every hearing to inquire whether the couple have considered mediation as an option. And if they haven't, if the judge is not satisfied that the couple have given proper consideration to that, can then require that they attend a mediation assessment meeting with a view to considering whether mediation would be a better option for them than to proceed with the litigation route. What are the advantages of mediation that we perceived as far as family justice is concerned? Well, clearly the prospect that a couple who are going through a relationship breakdown, who may well have children together, can reach an agreement which they've both bought into. It may not be an ideal outcome, but it's one that they have at least got some ownership of, is an advantage to them, rather than a litigation route which may be uncertain and produce an outcome that neither of them is content with. And of course, particularly where there are children involved, of course, the couple are going to have a long-lasting relationship. They're going to have to continue to communicate with one another, and a process which encourages them to find a way to communicate effectively with one another has a lot to be commended. Secondly, costs. By contrast with the commercial mediation route that Domnic described, where, as he was saying, it's often over-lawyered, and of course the mediator is charging quite a significant sum of money, family mediation is relatively cheap. In fact, the costs of family mediation are, I would say, at least a fifth of the costs of the litigation route, and quite often less than that. Typically, the costs are measured in hundreds of pounds rather than the thousands of pounds that couples would experience in litigation. And finally, time. Although, as I said, the mediation process would typically take place over 2, 3, or 4 sessions, it would be concluded within 3 or 4 months typically, whereas the litigation process would ordinarily take 6, 9, or 12 months to conclude. So there's a great attraction to many couples for mediating, but as Domnic has alluded to, it's a voluntary process. It's important that it is regarded as a voluntary process, because really, for it to stand the prospect of success, the couple need to buy into the notion that they're there to try to reach an agreement with one another. It is confidential, so the discussions that take place within mediation can't be referred to in any subsequent litigation if the mediation breaks down. The only exception to that is that any exchange of financial information that takes place within the mediation process is capable of being disclosed within subsequent litigation. Ideally, the mediation process would result in the couple reaching an agreement, and the mediator would then embody that agreement into a memorandum of understanding, which is a written record of the agreement that the couple have reached. In itself, it's not a legally binding document under English law, and so the couple would then refer back to their lawyers to draft up a legally binding document to reflect the terms of the memorandum of understanding. And in the vast majority of cases, that's exactly the route that a couple will take once a memorandum of understanding is in place. Is there a role for lawyers alongside the family mediation process? Well, most certainly there is. Often I find that I'm advising an individual going through mediation, and I'll give advice to that individual in between the mediation sessions. So there may be 2 or 3 or 4 weeks apart, but I'll take the opportunity to catch up with the client in between those sessions, talk through what was discussed at the last session, and then give advice as to things that he or she may wish to consider at the next mediation session. So it works hand in hand. The mediators and the lawyers work quite well together to try to make sure that the mediation process operates well. And as I say, it's a very regular feature of the family justice system in this country now. And although mediation services are a bit patchy geographically across the country, so some areas have much more availability of mediation services for family work than others, on the whole, there's a reasonable availability, and so most couples are able to access a mediator to assist them through the process. So I hope that's a helpful summary of the way that the family mediation process operates in England and Wales. I'll hand over to our next speaker.
Thank you, Richard. Before I would add some comments from my side, I thought we will use most of this time to know more from them. At the outset, there are 2-3 questions from my side. I'll just let you know the question, both Richard and Domnic, and then I'll proceed with my comments so that you can answer these things which many of the participants would also love to know. My first question is, Domnic, you said that most mediations are parties themselves finding mediators. So is there any process of accreditation or anybody can act as a mediator? This is my first question. Second, whether that is the same in the family dispute scenario also. Then the further question is, are the mediators lawyers or whether there are non-lawyers mediators? Now, how do you find working with non-lawyer mediators and lawyer mediators, which is better in your experience? And then to Richard, one more question is that when you have family mediations, the most of the talks in those, like inside the mediation room, will be on rebuilding the relationship or will be the other arrangements. I thought these were the questions which I let you know first before I make my initial comments. Now to come back, as we have heard from our friends from the UK, like as far as the Indian situation, like family law, yes, most of the family litigations we do mediate. Most of the family courts in India have the benefit of the mediation centers, which is the court annex mediation center, and the court provides them with the mediator services. And as far as the commercial matters are concerned, like it was pending litigation when the court referred mediation. Now the Commercial Courts Act came into force in the year 2016. We had an amendment in the year 2018 where section 12A was introduced, where it was made mandatory that there should be a pre-institution mediation for in all commercial cases, but then with the rider that where you don't need a urgent interim order. So that makes it a little difficult to go for mediation at every cost. Now, based on that, the central government of India has framed a rule for mediation, whereby the Legal Services Authority has been made as the nodal authority to appoint mediators to conduct this pre-litigation mediation. So that is the scenario in India as far as family cases are concerned and as far as commercial cases are concerned. So we must learn from them. Like as far as the percentage is concerned, we know that our percentage is much lesser. The percentage of success, it should be anywhere around between 25 to 30%. Especially in Tamil Nadu, it is even a bit lesser. That is our experience so far. And coming back to the other thing which was pointed out by Domnic is the mediation advocacy. Like there he said that more and more formalization of the process, which is a little bit affecting advocates filing mediation briefs and making it almost like a formal briefs. Here there are 3 fallacies which we all do. Is that first, we avoid mediation. We think that all right, it is the parties who are going to talk and settle among themselves, so it is nothing for me to do with. Generally, we adopt the technique of avoiding. Like you go to the mediation, it is all voluntary. Whatever thing you all agree, it will be fine. Then you consult me at the end. So this is avoiding, which is one fallacy which we commit here in this part of the world. Number 2 is that some of us, we attack also, like we also feel that a settlement is a secondary justice rather than the one which is in court. That is the second thing. Third one is the compete, like advocates coming into the mediation room and really start arguing the cases as if they were before the court of law. So these were the 3 things which we have to course correct if we have to get more results out of mediation. And we have to in fact learn from the other systems that the parties themselves, voluntarily finding mediators and settling more than 80 to 85% of the cases. We hope that we also reach that 80 to 85% in near future. And I conclude so that they can answer the questions, and the participants may have more questions to them also. We'll use the rest of the time more from knowing from them rather than me talking in this meeting. Thank you, Sriram.
Thank you, Bharat. I don't know if you can hear me okay, but just to pick up on those questions, there is, notwithstanding it's a private system, there is a very sophisticated mediation accreditation system in the UK. I mean, basically anybody can be a mediator. In practice, the vast majority are lawyers, and almost all of them have gone through training with one or other of the big recognized mediation providers, such as ADR.net or CEDR. But they're not the exclusive providers, because the parties have to agree on the appointment of the mediator. So they want to agree someone who is suitably trained and can show they have been trained and suitably experienced. So the mediators keep very good records of the number of mediations and the type of mediations they've been involved in. And if I put myself back, last year we had a mediation on a big case. Myself and my counterparty draw up a shortlist. We run it by our clients. We try and narrow the shortlist down. We pick a mediator that we are both happy to go with. He then produces a mediation agreement setting out the terms of reference and the procedure that will be followed and his fees, and then the mediation's up and running. So it's important from the mediator's point of view and from the parties that they're entrusting the mediation to somebody who's got the experience and the expertise, because it's a vital role. A very good mediator can get a settlement out of a case where both parties start the process off by saying, well, I'll go to the mediation, but there's no chance I'm going to settle. But actually, very often they do. With the skill of the mediator, that can be absolutely vital. The second point I probably answered in relation to that answer, which is that the vast majority of mediators, in my experience, are lawyers, or they are professional arbitrators who, although perhaps originally an engineer, have a great deal of legal training by virtue of having been a professional arbitrator for some time. But I very rarely come across a mediator that's not a lawyer, either a barrister or a solicitor or a former judge.
Yeah, I'm just picking up on what...
Is that the same in family stuff, Richard?
Yeah, it is really, Domnic. Yeah, so in terms of accreditation, like commercial mediators, family mediators have a fairly rigorous accreditation process operated by one of the leading mediation accreditation organisations, of which there are 6 in England and Wales. And it is quite a rigorous process, actually, and involves demonstrating experience of working along the mediator over quite a lengthy period of time and putting together a very detailed portfolio to satisfy the governing body of your ability to operate as a mediator, be accredited. Because of the need for the mediator to work alongside, or the prospective mediator to work alongside an existing mediator, increasingly it's been the case that new mediators have tended to be lawyers rather than non-lawyers. I think in the early days of mediation, going back 20 years or so, there were a reasonable proportion of non-lawyer family mediators in England and Wales, but those numbers have definitely dwindled, and now the vast majority of mediators are lawyer mediators. Whether that's an advantage or not, I don't know really. I think probably in the context of mediations relating to child arrangements, I'm not sure there's any discernible difference in terms of the approach that's adopted by a lawyer and a non-lawyer mediator, but possibly there may be some advantage in the case of a financial dispute to there being a lawyer mediator. In terms of the nature of the arrangements that are discussed in mediation, it is possible for a couple to talk about rebuilding their relationship in mediation if they both identify that as being an agenda item that they would like to talk about. And it's certainly not unheard of, although it is unusual for a couple to want to talk about reconciliation in mediation. In the vast majority of cases, a couple have already concluded that their relationship is at an end before they attend mediation, and they're really talking about the practical arrangements concerning their children, concerning their financial arrangements, flowing from their separation rather than any question of a reconciliation.
Thank you.
Bharata, it might just be helpful if I explain what the procedure in a commercial litigation mediation is like on the day. I don't know how it compares to the experience in India, but it is quite adversarial, even though it's a mediation. So typically, the parties will all meet with their lawyers and the mediator and have an opening sort of plenary session where everyone is round the table. And I actually think, having been a conducting solicitor in many of these mediations, that's possibly the most important session of the day of the whole process. Because from a party's perspective, whenever they hear the other side's case in the course of a normal litigation case, it is always sanitized by being delivered by your own lawyer. So if I'm the party in a case, I'll get a letter or an email from me saying, we've had the defense submissions in and they say this, but of course our argument is that, and they say this, but our argument is this. It's all in context. It's all nicely sanitized. It's in writing mostly.
Okay.
The first time you hear the case delivered from the horse's mouth, from the advocate for the other side, fully, no holes barred, both barrels, is on the first day of a trial, by which time the parties have invested a fortune to be in that position. And we've all been in trials where you hear your opponent's opening and your heart sinks. You think, oh, crikey, they have got a really good case. And then you steady yourself and say, actually, no, it's okay. We've got a really good case as well. And you go with your case. Imagine if you're the paying party in that process and what that cost consequence is. So you get a dress rehearsal of it, really, in a mediation in this plenary session, where my job as the advocate is to absolutely rip their case to pieces and put my client's case forward as best I can, obviously in a polite and civilized way, but notwithstanding that, in a very assertive way. And I always brief my clients when we're going into a mediation, please treat this like a game of poker. No matter how alarmed you feel when they are ripping our case to pieces, please don't let it show. I've seen my opponent's clients writing notes, scribbled panic notes halfway through what I'm saying. You only usually have 5 or 10 minutes, so it has to be quite impactful. And then you go off. Both parties have a pop at one another. Sometimes, there's more than one party. You then go off into separate rooms, and you can spend sometimes hours just with your client while the mediator is in the other room or other rooms talking to the other parties. So it's a very strange process where you start off with this very intense adversarial session. You then break off into separate rooms and the mediator shuttles between you and picks holes in your case or promotes your best case or best parts of your case, and then eventually starts talking about possible outcomes. And I say in 80% of cases, it ends up with a settlement. But that process itself, the key thing is you have to have a decision maker there, because unless the decision maker in your client's camp, and most mediators insist that real decision makers have to be present, they don't experience that first session and the impact it has. And it's not the same having somebody report it to you over the phone during a coffee break. It has nowhere near the same impact. So it's absolutely vital that decision makers are there and that parties have the chance to influence what's going on. I've had 2 mediations where the managing director of the company I was representing wondered whether he was entitled to speak at the mediation. I said, it's absolutely fine, you should speak. Would you like to do part of the opening address? Oh yeah, that'd be great. So on 2 occasions, the managing director looked his opposite number in the eye and told him how he felt he'd been treated by that company. And in one of the cases, I am absolutely convinced that the managing director's 2 minutes was crucial to getting a settlement achieved quite quickly, because the managing director of the opposite company, who hadn't been involved in the day-to-day stuff, was absolutely mortified that his company was being perceived as being really cavalier and ruthless and without many scruples. And I'm sure it generated a momentum that simply me saying it wouldn't have done. So I think it's important, picking up on something Bharat said, that the parties have some engagement in the process. And actually, I think it could lead to a successful outcome.
Thank you. Sriram, questions are coming.
Yeah, they can in fact ask. Vijay Krishnan Rangaswamy. Vijay Krishnan Rangaswamy, are you here?
Yeah.
Domnic, he seems to have a question exclusively for you.
Okay, far away.
Yeah. Yes, Vijay Krishnan, you can ask your question directly.
Sorry.
Oh, yes, Mr. Vijay Krishnan, you can ask your question directly.
1 second, please. 1 second. Yeah, I think I raised the question. Can you hear me?
Yep, fine.
Yeah, I raised the question whether there are any instances in England where a losing party is imposed additional costs because he didn't opt for mediation and opted out of mediation in the first instance.
Yes, there are instances, and not just a losing party. A losing party can be penalised with costs orders against them, but even a winning party has been penalised with a costs order, whereby they've won the case but refused to mediate during the life of the case, and the judge at the end of the trial has had this drawn to his attention, formed the view that it was an unreasonable refusal, formed the view that had there been a mediation, a similar outcome could have been achieved at least a year earlier with a huge saving in costs and time, and is therefore declined to give the winning party all of its costs. And those sorts of judgments, there's been several of those, have been designed to try and encourage parties to give mediation a real crack.
Right.
There have also been some cases where parties have gone to mediation, but have been they were not engaging with the process, they through the motions. And again, there's been a reported case of a party who did that being penalised with costs as well. And in fact, in that, very difficult for the mediators to give evidence, but the party evidence, it was a charade and penalised the party.
Thank you very much.
Okay. We now have Varsha Pillai.
Hello.
Varsha, please.
Good evening. The question is posed to Domnic and Richard. So in Britain, if the parties opt for mediation and it eventually fails, do the courts again start from the beginning with the analysis of the facts, or do they go from where the mediation stopped?
Okay. So in the commercial litigation sector, the mediation is entirely private. So if the mediation fails, the case resumes without reference to the mediator. That's all history. Whatever was said and whatever documents were exchanged in the mediation are all private. The court case continues as it normally would have done. And when it gets to the judge, he won't necessarily even know there's been a mediation that failed. He may know nothing about it. probably won't. And so he will simply try the case on the basis of the way it's presented by the parties and their advocates in the normal way. And whatever was said and done at the mediation will be completely lost in the history, unless one of the party at the end of the case, after the judge has made his decision, is of the view that the conduct of the mediation or a refusal to go to mediation is relevant to the issue of costs. But that's only at the very end of the process, once the judge has decided what the judgment is.
Yeah, and the same applies in under family law as well. In most cases, mediation takes place before litigation has begun, and if the mediation process fails, then the parties will have to start the litigation process at that point in time. On some occasions, but only a few, the litigation process will be underway when perhaps the court has encouraged the parties to consider mediation when they previously haven't given proper consideration to it. If mediation then failed, then the court process would restart from the point that it had reached. But that's a fairly rare scenario. Most mediations in the family law context take place before proceedings have been issued. And as Dominic said, the same applies in the family justice system. In many cases, because it's not a court-led process, the courts, if they are involved in resolving a couple's dispute, won't be aware even that mediation has taken place. There's a slight difference of emphasis in relation to costs under family law in England and Wales, in that there's an overriding principle that there should be no orders to costs, that both parties should be responsible for their own costs irrespective of the outcome. So it's not a winner gets cost scenario. Having said all of that, it is in theory possible for the court to make an order for costs against a party if their conduct suggests that they should have conducted the case in a particular way and their conduct has been reprehensible. Then it's possible for the family court to make an order for costs against that party. And again, in theory, a refusal to attend mediation could be taken into account, but rarely is, I have to say.
Yeah,
Okay.
thank you.
Okay, thanks, Varsha. The next person to have a query is Sai Krishnan. Sai Krishnan, Tyagarajan. We're extremely happy for that radio broadcast, but could people unmute themselves? Thank you very much. Sai Krishnan, are you here with your query?
That was Sai Krishnan.
Oh, that was Sai, is it? Sai Krishnan.
Hello?
Yes, you're on. You're live.
Yeah, yes. I just wanted to know the status of a pre-litigation mediation in UK, whether it is given the status of an award as in an arbitral proceedings. And what is the position in India also, so that we could analyze both.
Sorry, I didn't catch that. It's the connection's not great. So can you just say that again?
The question is that if there is a pre-litigation mediation and there is an agreement between the parties. Now, what about the enforceability? Is it just a contract, or is it enforceable like an award of an arbitrator or a decree of a court? That's the question.
And he seeks the status both in India and in the UK.
Yeah, let them answer.
Yeah.
Okay. So in England, mediation agreement is the only outcome of a mediation that's enforceable. So once the parties have reached an agreement in a mediation, that's put into a document, an agreement, and that is enforceable in the same way a contract is. So that if a party has agreed that it will pay a sum of money in 14 days' time and they fail to do so, then they're in breach of the contract and action can be taken on the agreement itself. And most times the agreement is actually drawn and signed then at the mediation.
So there's quite a large contrast there between commercial mediation in England and family mediation. So an agreement reached at the conclusion of a family mediation in England and Wales would usually be embodied in a memorandum of understanding, which is a record of the agreement that the couple have reached, but that is not legally binding as between the couple and isn't capable of being enforced. The couple would then normally instruct lawyers to draw up legally binding and enforceable documentation for the court to then approve, so that it does become binding and enforceable upon them. But the document that's produced at the end of the mediation process isn't in itself a legally binding and enforceable document. I have to say, though, rarely is it the case that a couple, that an individual tries to renege from an agreement reached in mediation. Usually, if a couple have invested sufficient time and effort in a mediation process to produce an agreed outcome, it's fairly rare that one or either party will try to resile from that agreement after that investment of time and money into the process.
Thank you, Richard. Lordship.
No, you can answer, but mostly we'll touch on Mama Act and then.
Yes.
Yes.
So as far as the Indian situation is concerned, like like family matters, we all know that unless a decree is granted by the court, therefore it has to go to court and a consequent order has to be passed, even if there is a private mediation between the parties. Now, as far as the commercial and other aspects are concerned, a pre-litigation mediation, there are two views which are ongoing in India. Now, first, as far as these commercial mediations are concerned, by the virtue of the Commercial Courts Act, now a pre-institution mediation, Section 12A of the Commercial Courts Act says that it will be an award of an arbitrator as per Section 30 of the Arbitration and Conciliation Act 1996, as if the parties were agreed to a settlement before an arbitrator. Therefore, it will be drafted as if it is an arbitration award, and it will be enforceable as if it were a decree of the principal civil court directly. So if one party breaches, straight away execution petition can be filed and a suit need not be filed. As far as the mediations, pre-institution mediation under the Commercial Courts Acts are concerned. Now, apart from the Commercial Courts Act, even prior to the coming into force of the 2018 amendment, there were two views which were possible. Like in Afghan's case, it said that a pre-litigation mediation, that is a mediation happening privately between the parties, can be equated to the conciliation under the Arbitration and Conciliation Act, and if there is an agreement, it can be reduced into an award as if it is an award passed on a consent. And then there is another school which says that pre-litigation mediation cannot be equated to conciliation, and therefore it would be as best as an agreement only. So still in India, the law is a little bit remains to be unsettled. There are two schools of thought, and that is the position today, Sai Krishnan.
Okay. The next person is Surya Narayanan, G. Surya Narayanan, called Suri by all of us. He has an interesting question on the context of an earlier discussion a few minutes ago as to whether costs can be imposed or not. Suri.
Yeah.
Oh, Suri, who is this? Suri, hold on. Who is this question? Who is this question for? Our friends from across the seas.
Yes.
Okay,
yes.
Great.
Sure. Because in India, pre-mediation is available in Commercial Courts Act, and in Civil Procedure Code, after the filing of the suit, we have mediation. There also there should be similar provision which should ask for a mediation either prior or after. If that is the case, why the party should be penalized with a cost because he did not choose for a mediation?
Okay, so in England, the mediation can take place at any time. What's an interesting wrinkle on this is it's sometimes you have a contract which says that before you can go to court, if you've fallen out with your contracting party, you have to go to mediation first. But actually, you can mediate at any time. And even where the contract contains such a clause, it's not a bar on actually issuing proceedings. It could be something that's taken into account in costs awards, but despite the wording of the contract, which suggests it's a precondition to being able to issue proceedings, it is not in fact. So that's in terms of when to go to mediation in England. Parties can go at any time, and there's actually a lot of debate about when is best. The most effective time to go to mediation in terms of saving costs and time is very early in the dispute, because obviously if it can be resolved then, you don't spend a fortune on lawyers and getting proceedings going. On the other hand, you know very little at that stage about your opponent's case, because no pleadings have been exchanged and no evidence has been exchanged. So the other school of thought is you need to at least see the pleadings and the evidence. Of course, the corollary of that is, by that stage of the case, you've spent a lot more money, so the potential saving in getting the case settled is reduced. And so there is a real decision for parties to make as to exactly when they should go to mediation and try and get the case settled.
Yeah, and in the family law context, the same issue applies. The mediation is available to couples at any point in time, so they can mediate at any stage. As Dominic was just saying, timing is always an important issue and is an interesting question. And our experience from a family mediation perspective has been that, generally speaking, the earlier the couple can contemplate and be referred to mediation, the better in terms of the prospects of A, them being willing to mediate in an effective way, and B, them being able to reach an agreement. Invariably, if a couple mediate further down the line, their positions have become more entrenched, and it becomes more difficult to persuade them to firstly mediate and secondly to engage in the process in an effective way so as to reach an agreement.
Okay.
Thanks. It was very interesting to talk to you both.
Thank you.
Thank you very much.
Okay. And the next person who would like to ask something is MP Jaisha. That's how the name appears. I presume it's MP Jaishankar. Is it? MP Jaisha?
It is MP Jaisha, Sriram.
Huh?
Sriram, this is Jaisha only.
Oh, hi.
Hi.
Oh, hi.
You seem to have forgotten my name. Okay. Good evening to all the panelists, and happy birthday to Justice Govindaraj, sir. And my question is, when mediation is such a prolific idea, and moreover in India where we've got a lot of pending cases, where there's huge backlog, why is that mediation is not given that due advantage and try to explore that aspect more and settle things more easily in India especially? And where we have failed, why is it failing? And the result is only 25 to 30%.
Yes. Basic thing. You heard. Hear me?
Yeah, I can hear you, sir. Yes.
Yeah. That the basic thing is, when everything comes for free, don't know the value of that. You heard that from this panelist from UK, that the cost of mediation is very high. We say that it's cost effective and free time effective, and we are giving it free of cost. So sometimes, I don't blame anybody, but sometimes if you want to switch over to some other judge or avoid some judge, you want to protract the proceedings, you switch over to mediation also. That is one part of it. Second thing, awareness of mediation, that it is not widespread so far, because it is a voluntary process and it can be stalled by the parties because of lack of information, or the lawyers, or anybody else, and other parties, third parties playing in this mediation or process, and family members. For example, I'd say third party means that family members, in respect of family matters, that girl and boy may be willing to unite back, but the parents on both sides or somebody else, they will hold them back. So these are all the things which lack of information, lack of awareness is one part of it. Second thing is it is comes free, that at any stage you can walk out of this mediation. Third thing, that you want to probe something, that find out what is the trump card of the other side and find out what is he is holding back and other things, get information. And that's the true sense, because caste is imposed in UK and other places because they are not sincerely attempting. When judge feels that if there could have been a settlement by mediation, if they sincerely attempted to, unreasonably they walked out of it, they impose caste. Here it is not so. Here it is for free, and if your not party is not willing to settle, they can go back, and the mediator cannot be called as a witness to find out who is at fault and who is unreasonable and other thing. We cannot take the judge will not be biased because somebody is not cooperating in the mediation and all that. These are all the stumbling blocks where we have to grow further, and we need to have more experience also, and parties should be cooperative, so that they should have a sincere attempt and sincere willingness to settle. This, mostly that we are in an adversarial system, we want to say that who's right and who's wrong and who won the case and who lost the case. It's not that it is on the basis of needs, whatever I want, then to settle it. Once the mindset comes that we can settle the case and we can get by peace, then it will succeed more. Now we are in the trailing stage, then we'll slowly will improve. That the percentage is improving. Most of the places. And second thing is that infrastructure facilities. People have to travel from taluk headquarters to district headquarters, and Madras, like places like Madras, then you have a lot of computation facilities, whereas in village areas and all that, it is very less. So we need to train more mediators, and we have to set up more centers in grassroots level. Then you'll find there will be a dramatic change. When people understand this is a very beneficial system, it's all these are, there'll be success rate will be high. In like Bangalore, parties have the satisfaction. Those who are sincerely attended, that they have the satisfaction. I will not say that mediation, there is success and failure in mediation. Mediation makes you to understand what is your position, what is your need, and what you have in your mind, what is your cases. So that even if they are not settling in mediation center, tomorrow before the court, they'll have the settlement. They may reach out the settlement. Sometimes, if they want the matter to be settled by the judge rather than the mediator. There are a lot of other issues, ego problems and other issues are there. That's why slowly we'll improve more.
Thank you, sir. Thank you so much. Happy birthday once again, sir.
Thank you, sir.
Richard, incidentally, having heard Justice Govindaraj talk about the family of the boy and the girl, you should remember it might be slightly difficult for people like you from the UK to understand. In India, a marriage is not just between two individuals, it's between two families, two seriously extended families.
Yeah.
Okay.
Yeah.
So
there are lots of people have an interest in the outcome of the mediation process, basically.
Oh, absolutely, absolutely. Why go into the mediation process? The actual marriage per se, even if we do not invite outsiders, we're talking about 250. That's the size of our families.
Yeah.
Okay, right. And I see a lot of lawyers here. I don't want to name the lawyers, but you're not taking this option. This is the only chance you're getting in public of asking questions to a sitting judge as a matter of right. Unfortunately, none of you are taking up this opportunity. Therefore, I call Bala. Bala seems to have a lot of questions. I hope it's for Justice Govindaraj. Bala, come.
Thanks, Sriram. Yeah, sorry, but the questions were actually directed to Richard. I'm not troubling his lordship on his birthday today. So,
no worries.
If I can,
you ask anything.
Thank you, Milad. So the questions were stemming from whatever Richard had in fact spoken about. A couple of things that struck me as being fundamentally different from the way mediation works here and in the UK, at least insofar as family mediation is concerned. One is, you mentioned that financial aspects which have been revealed in course of mediation could be used later during court proceedings. So I wanted to know the circumstances where such information which has come out in course of mediation can be used in court proceedings, number one. Secondly, you had mentioned that once the mediation process is completed, the parties enter into an MOU, and thereafter it is left to the lawyers to draw up a binding agreement which the parties will sign. So my question is, what happens if, let's say, an MOU is arrived at and ultimately an agreement is not drawn up between the parties for some reason? So is the MOU by itself binding, or what happens to the mediation process which ended in an MOU but did not ultimately get translated into an agreement properly drawn up and signed?
Okay, yeah, thank you very much for those questions. As far as the financial information that's exchanged within the mediation process, financial disclosure in the context of family cases in England and Wales is always conducted on an open basis. And those rules apply to mediation as well as they apply in any other process, whether it be litigation or arbitration or any other voluntary negotiation process. So the rules are no different as far as mediation is concerned. Information that's exchanged by a couple as part of the family mediation process is capable of being referred to outside that arena. And so if the mediation process were to break down, then information that the couple have exchanged about their financial resources could be referred to in subsequent litigation. In reality, if litigation flows as a consequence of a mediation having broken down, the couple would have to exchange financial disclosure again within the litigation process. Now, it may be that they've already got a good insight into their respective financial resources through mediation, and that really will be just a repeat exercise. But nevertheless, that insight could be referred to in the litigation process. And then your second question in terms of what happens once matters are completed, as you rightly say, an MOU is produced. The expectation would usually be, particularly in the context of a financial case, that MOU would then be converted into a court order, which would be binding and enforceable on the couple. If for whatever reason the couple chose not to take any course of action to have the agreement in the MOU converted into a legally binding document, they're not obliged to do so. But of course, they then don't have a legally binding and enforceable agreement between themselves. So in the context of a financial case, if one party didn't then implement what had been agreed, the other party wouldn't be able to enforce that based on the contents of the MOU. So there's a contrast between what happens in family mediation in this country as opposed to the contractually binding nature of a commercial mediation that Domnic described earlier on. In the context of child arrangements, in this country, most cases which entail disputes over child arrangements no longer result in a court order being produced at the outcome. In most instances, a couple are encouraged to reach an agreement that they informally regard as binding upon themselves, but isn't actually embodied within a court order. So it would rarely be the case that an MOU concerning child arrangements would result in a court order anyway. Usually there would just be a record in that document of the agreement that the parties have reached, so that if they need to refer back to what that agreement was, they can just look at the MOU, but it wouldn't be converted into any legally binding document.
Thank you. Thank you very much, Richard.
Thank you.
Okay. The next person to have a query is Vaitishwari. Vaitishwari, could we have you with your query?
Hello, sir. Good evening to all. So my question is that whether the mediation which is being settled out of court, does it require registration, not with respect to commercial aspect, with respect to like family disputes and other related stuffs? So does it require registration, and what would be the effect of it if it is not registered?
Vaitishwari, this is probably aimed at the situation or scenario in India.
Yeah, in India, and I would also like to know with respect to UK aspect also.
Okay, probably Domnic or Richard could answer, after which we could have Bharat respond.
I think Richard, perhaps. I think the question is in relation to family mediation rather than the commercial one. So, is that correct?
So, yeah.
Yes,
Okay. So an agreement reached in family mediation wouldn't be registered as such in court unless a couple took the course of action that I was just explaining in the answer to the previous question, which is that if they've reached an agreement in mediation and they want that to be legally binding and enforceable, or contained in a legally binding and enforceable document, then they would instruct a lawyer to produce a document, and that would then be lodged with the court for a court to ratify and approve and seal. And so if a couple, for example, reached an agreement regarding financial arrangements, that would be contained within the MOU. They would then, once they'd signed the MOU, would then engage lawyers to draw that agreement up into a court order, and then subject to the couple agreeing the terms of that court order and signing off that order, and that order being lodged with the court for a judge to approve, that agreement at that stage would then become legally binding and enforceable. But it's for the couple to take that course of action, to lodge the documentation with the court, and to effectively prompt the court to, well, I suppose register, if you like to put it that way, or approve the court order. The onus is on the couple to do that.
Okay, thank you, sir.
Thank you.
With reference to Indian situation, like, let us first, our law requires that regarding the status, for example, a divorce, okay, they cannot by a private agreement after mediation, they cannot agree, then they say they cannot declare themselves as divorced. So therefore that has to go to the court. Now what else can be within the family agreement? For example, if there is any exchange of properties or other things, then so far it requires any transfer in an immovable property, then if the document is compulsorily registrable as per the provisions of the Registration Act, then they have to execute appropriate document, either transfer, settlement, exchange, whatever it is. If a private mediation, in a family mediation, it has clauses which transfers interest in the immovable property, then to that extent they have to register the appropriate document. So regarding the child custody and other things also, it will be at best an enforceable agreement between them that doesn't require any registration, but if they go to court, they can use it as an agreement which entered into between themselves. It is one of the documents supporting their case.
So specifically to custody, sir, if that agreement, but if it is not registered, so the validity, it might be a document. So how far we can enforce it in the court of law?
Yes, ultimately in a court of law, the court will act as a parent's party, and it will only consider the best interest of the minor and also take into consideration that agreement between the parties. And so long as there is nothing against the interest of the minors, the court will ultimately give effect to that agreement. But it is only a document, it is like any other communication or document which is.
Okay, thank you, sir.
Okay, we now have Alamelu with Alamelu.
Sir, good evening. Good evening, sir. This is Alamelu. Many happy returns of the day, sir. As Jaisha greeted you, and I would like to know that a course is being started for mediation and reconciliation. I heard so. Is it in the near future, sir? Are you able to hear me, sir?
We are able to hear you, but we are not able to see you.
No, I'm in a non-formal dress, so that.
There is some little disturbance there.
Ah, yes, sir. I didn't hear you, sir.
Yeah, you are not. There is some disturbance there.
Okay, sir. Okay.
Lordship, her question is whether any courses like post-graduation courses are likely to be started in this speciality of mediation and conciliation shortly, is there any move? That is what her question.
That's her question.
Yes.
That this curriculum and these law colleges, they have mediation as a subject. In Nalsar, that along with in association with this mediation center there, that center, I don't remember the name. They have a course on mediation. Now let us we have to see that whether the universities are giving any courses on this undergraduate courses in mediation or not. Let us hear Bharat about it. I think he may know a little more about this curriculum.
Yes, sir. Thank you.
As well, at the undergraduate level, it is ADR is almost included as subject, and in some universities, post graduation is also there in ADR, and people are permitted to do research. And some of our presiding officers, many of the students are also doing research in mediation, and that is there even in the post graduation research level in many universities, including National Law University in Bangalore.
The degree on
not in the undergraduate level. It has been instituted as a subject both in the social work and sociology department, as also in law degrees, and there is postgraduate specialization in ML, Master of Laws. It is there in National Law School, Bangalore.
Thank you.
Okay. If anybody else has any query, or any of the panelists have any question to ask of each other, Bharat, Richard, Domnic, Justice Govindaraj.
I think there's one more question is coming from a participant.
Oh, that's the guy who's in charge of, who's partly 50% in charge of the back end of the session.
He will be junior.
Yeah. Veda, you can probably ask your question. I think that's easier.
Good evening. Good evening to all the panelists. So, how do the systems in India and as well as the UK protect the confidentiality issues of the parties who come into the mediation? And as a follow-on question, can if the mediation fails and based on the intention of one of the parties, can a mediator be compelled to testify about a party's position in the mediation?
That Bharat, you can answer, because I already said mediators cannot be called as a witness.
Yes. The Indian situation is that our mediation rules strictly enforce confidentiality. Now, the courts will never encourage the parties sharing confidential information, even if it is anything shared that will not be taken into account. A mediator will never be summoned before court to testify about what happened in mediation. So that is all clearly taken care of by the mediation rules framed by our High Court, Madras High Court, as well as the various high courts in exercise of their powers. Every High Court as well as the Supreme Court has framed rules, mediation rules. So in that rules, it is taken care of that the confidentiality is guarded. And as far as the private mediation is concerned, like if you can see section 34 of the Arbitration and Conciliation Act, now if the confidentiality clause is violated, you can see that is one of the ground even for the parties to wriggle out of the mediation conciliation agreement or the award by consent if the confidentiality clause either under 64 or 71 is violated. So that is a specific ground which is given. That is how arbitration and conciliation are protected. The court has mediation, our mediation rules protect it, and there has been some decided case law also. Justice Kaju himself has given a judgment sitting in the Supreme Court that no mediator will ever be called as a witness, and then confidential matters will never be discussed in court, or they will not be taken into account as evidence. That is the Indian legal position. Over to them.
Richard and Domnic, is the system in England slightly different, or is it basically the same with even more stringent restrictions?
It's probably less restrictive in some respects. So any commercial mediation involves the drawing up of a mediation agreement, which is a binding legal agreement in which the parties agree to keep confidential information that they receive in the mediation process. If notwithstanding that, and the mediation fails, a party wishes to adduce evidence which they obtained during the mediation process, the court would rule that as inadmissible, and a party could apply for an injunction preventing that evidence from being admitted, and a judge would readily accede to it. For that reason, in practice, it's rare for a party to try to use information obtained during the mediation in the course of the case, if the mediation fails and the case proceeds. Having said that, most of the information that's disclosed in a mediation, most of the evidence, is evidence that will be disclosed in the case anyway. So it's unusual for a situation to develop where something has been tabled in the mediation which isn't actually evidence in the case in any event. But if it were to be the case, then it would be a breach of confidence and the court would rule it inadmissible. The court's very keen to support mediation, and a fear over documents and information being used against a party is a barrier to mediation. So the courts are very keen that that shouldn't happen and would readily grant the order. As far as the second part of the question is concerned, there's no specific rule that a mediator cannot be called to give evidence. But it is very unusual for a mediator to be willing to give evidence, mostly because in the commercial sector, they perceive it as being unhelpful to their reputation as being neutral. And it again could be perceived as being a barrier to mediation if the party's conduct is being scrutinized, or they feel it is, when really the mediator's main role is to be trying to broker a deal. And so there's a very great reluctance for mediators to get themselves into a position where they're giving evidence against one of the parties. It's not unheard of, but it's very rare.
Okay.
Thank you.
Richard, do you have anything to add?
I'm not sure if Richard's still with us. I don't see him on the screen.
Oh
yeah, I hear his voice.
Yeah. So there's just a slight difference there, a slight nuance in terms of the family mediation arena, in that a mediator can't be compelled to give evidence to the family court concerning discussions that have taken place in a mediation that he or she may have presided over. That's the rule that applies in the family justice system. But as Dominic was saying regarding confidentiality, it is a confidential process, family mediation. A couple at the beginning of the process would be asked to sign an agreement to mediate, in which they would both acknowledge and agree that the process is a confidential one. There are two exceptions to the confidential nature of the discussions that take place within family mediation. Those are where a disclosure is made of a safeguarding issue, which then may need to be revealed outside of the mediation process, or separately, if a party discloses a criminal offence during the family mediation session, then again that's capable of being disclosed outside the mediation arena. But otherwise, all discussions that take place within family mediation are confidential.
Yes, like Mr. Domnic said, yeah, like Mr. Domnic said, that there are slight exceptions where somebody confesses that there is something against the national security or he has committed heinous offences, and they cannot claim the privilege of confidentiality, that he loses that privilege. There are certain exceptions to that. In India also, we are following that. And mediator will immediately close down the mediation. He has the right to close down the mediation. And if required, it can be reported also.
Okay.
Thank you.
Thank you. And so, Ved the Whale, did you get your answers?
Yes, sir. Thank you so much to the panelists.
Okay. So, this is a slightly unusual thing in the sense that as far as I'm talking purely from the point of view of a litigation lawyer that I am, I'm surprised that so many lawyers would like to attend a session on mediation, which obviously is very, very distinct road from what a litigation lawyer travels on. And therefore, this was an attempt by us to try to add to the information and enlightenment that mediators at present in India have by listening to the panelists, by hearing their interaction, and to aid those lawyers or maybe chartered accountants who want to go into mediation as a profession. And like Domnic said, it's something that does not have any restriction. Being a mediator does not mean that you have to be this particular professional or otherwise. So thank you very much. This was a session that was, I'm sure, well received by those who wanted to listen to this for specific reasons. And we have this comment from Rajendra Raghavan, a practicing lawyer at the Madras High Court, saying it was a wonderful insight regarding the mediation process in the UK. Some of the principles and precedents like compensation, etc., could be pursued here in the Indian mediation arena. Please pass on my view. So thank you very much to all the panelists. Special thanks to Domnic and to Richard for their time and for their the casual manner in which they have approached the entire session. And special thanks to Justice Govindaraj. Happy birthday again.
Thank
you. No, you're not getting off lightly. We're coming home for something.
I'm ready. I have the armed with lockdown.
Absolutely. And special thanks to Bharata as well. And we're sure that Domnic, the next time that you're here in town, this part of the world, please do allow us to host you once again. And thanks very much to all you people. And BFS Legal and our office, we had a lot of fun, We had a lot of fun in presenting this to you. I hope you enjoyed being a part of the session, and we hope that you enjoyed watching the panelists interact. Now we go our separate paths, and Bala's office, which is organizing LEX TALK, have a session on Admiralty law tomorrow evening, Indian Standard Time, for those of you who live in the UK, Admiralty law in India, and we have custody laws across continents, courts, and religions. That's day after tomorrow, 5 p.m. So thank you very much. We hope you enjoyed this session. Thanks again to the panelists and Justice Govindaraj, Domnic, Richard, and Bharat. Thank you once again from both Bala's office and from our office. Thank you very much. Thank you.
Thank you. Cheers.
Thank you. Thanks.
Bye.
Bye.